5 seconds to go. Start. It is generally difficult in cases of deaths in police custody to secure evidence against the policemen responsible for resorting to third-degree methods, since they are in charge of police station records which they do not find difficult to manipulate, as in this case. The offence is of a serious nature, aggravated by the fact that it was committed by a person who is supposed to protect the citizens and not misuse his uniform and authority to brutally assault them while in his custody. Death in police custody must be seriously viewed, for otherwise we will help take a stride in the direction of police Raj. It must be curbed with a heavy hand. The punishment should be such as would deter others from indulging in such behavior. There can be no room for leniency. In Munshi Singh Gautam 2005-9 SCC 631, this court held that peculiar type of cases must be looked at from a prism different from that used for ordinary criminal cases, for the reason that in a case where the person is alleged to have died in police custody, it is difficult to get any kind of evidence. The court observed as under. Rarely in cases of police torture or custodial death, direct ocular evidence is available of the complicity of the police personnel, who alone can only explain the circumstances in which a person in their custody had died. Bound as they are by the ties of brotherhood, it is not unknown that police personnel prefer to remain silent and more often than not even pervert the truth to save their cliques. The exaggerated adherence to and insistence upon the establishment of proof beyond every reasonable doubt by the prosecution, at times even when the prosecuting agencies are themselves fixed in the dock, ignoring the ground realities, the fact situation and the peculiar circumstances of a given case, often results in miscarriage of justice and makes the justice delivery system suspect and vulnerable. In the ultimate analysis, society suffers and a criminal gets encouraged. The courts must not lose sight of the fact that death in police custody is perhaps one of the worst kinds of crime in a civilized society governed by the rule of law and poses a serious threat to an orderly civilized society. Torture in custody flouts the basic rights of the citizens recognized by the Indian Constitution and is an affront to human dignity. Police excesses and the maltreatment of detainees, under trial prisoners or suspects tarnishes the image of any civilized nation and encourages the men in khaki to consider themselves to be above the law and sometimes even to become a law unto themselves. Unless stern measures are taken to check the malady of the very fence eating the crop, the foundations of the criminal justice delivery system would be shaken and civilization itself would risk the consequence of heading towards total decay, resulting in anarchy and authoritarianism reminiscent of barbarism. The courts must therefore deal with such cases in a realistic manner and with the sensitivity which they deserve, otherwise the common man may tend to gradually lose faith in the efficacy of the system of the judiciary itself, which, if it happens, will be a sad day for anyone to reckon with. Stop.